Hi, I'm attorney Ben Schwartz. Today we're going to talk about what to expect when going to a mediation settlement conference in a personal injury case. I handle personal injury cases, and I handle cases in Delaware and in Maryland. Other attorneys in my office handle cases in Pennsylvania and New Jersey as well. And in a lot of these cases, especially more substantial personal injury cases, we go to what is called mediation settlement conferences. A mediation, it's a fancy word, but basically it means put everybody in a room and see if you can work out a settlement. And so what I want to do today is I want to talk about what to expect if you have been injured in an accident, you've got a personal injury claim, and your attorney tells you, hey, we need to go to a mediation settlement conference. Basically, prior to the mediation, it's likely that the attorney is going to put together a package of documents, medical records, medical reports, lost wage documentation, a copy of the police report if this was an auto accident, narrative reports from the treating physicians, other documentation to substantiate the claims. He's going to put together a package and he's going to summarize it, and he's going to give it to the mediator. He's not going to give it to the other attorney, just to the mediator, and let the mediator know what the case is about. Also let the mediator know the strengths and the weaknesses of the case. So when I say that, what I mean is that every personal injury case has strengths. Most personal injury cases have weaknesses too. And so, for example, if you were injured in an automobile accident and you were driving, perhaps in the case you state that you had the green light and you went into the intersection on green, but perhaps there's a witness who says they thought that you had the red light. And so that would be a weakness. If the case goes to trial, perhaps the jury will find that you didn't enter the intersection on green. And so that's a weakness in the case because it could result in a reduction of the jury verdict, or it could result in a defense verdict if the case goes to trial. That's something that I would want to let the mediator know about. The mediator also ought to know the particulars of the injury, the amount of damages, the amount of money that's being claimed. So, for example, if you have a case where there's $150,000 in medical expenses, you need to let the mediator know that those medical expenses exist so that the mediator is on the same page with you. So prior to the mediation, the attorney representing the injured person, representing the plaintiff, puts together a mediation package and submits it to the mediator. Who's the mediator? The mediator is generally going to be another personal injury attorney who really has nothing to do with the case. Someone who's completely neutral, and it doesn't really make a difference one way or the other to this individual whether the case goes to trial, whether it settles for a lot, settles for a little. They're not really interested in the outcome. They're interested in the process, in helping the case to move along towards a settlement. But generally, the person that we're selecting as our mediator in our personal injury cases is going to be a personal injury attorney or a former judge who has a lot of experience in handling other cases of a similar nature or type. So then after we've selected our mediator, we have put together our mediation package and submitted it to the mediator, we're going to show up in the mediator's office. It's going to be, so let's say I'm representing the plaintiff, so it's going to be me and my client, the plaintiff, the injured person. On the other side, the defense attorney should show up. Also, most of the time, a claims representative who's handling the case for the at-fault person's insurance company is going to show up at the mediation, and of course the mediator will be there too. It is actually rare for the at-fault person to show up to the mediation. In my opinion, there's not usually a good reason for the at-fault person to show up. So To give you an example, if we have a car accident case and my client was entering the intersection on a green light and another driver ran a red light and smashed into my client, that's not a situation where I would expect the at-fault driver to show up at mediation. You know, a mediation is, the purpose is not to argue over who's right or who's wrong. And also, when you're handling personal injury claims, typically speaking, there's an insurance company that's going to pay the damages award, the compensation to the injured person. So you don't really need the at-fault person to show up. But we get to the mediation settlement conference, and typically everyone in the room signs an agreement to mediate. The big item, the big idea of signing the agreement to mediate is you're agreeing that everything that happens in that mediation settlement conference will remain confidential. So you can't call the mediator at trial if the case doesn't settle. You can't call the mediator at trial to say what they were told in a confidential setting by the at-fault driver's insurance claims adjuster or the at-fault driver's attorney. It's confidential. The mediator will begin the mediation settlement hearing or process by asking the plaintiff attorney if they have anything they want to say about the case. The mediator may ask the injured person if they have anything that they want to say at the settlement conference table. They'll ask the defense attorney if they have any input that they want to give. And then after everyone has their say, the mediator typically will split the parties up, put the plaintiff and the plaintiff's attorney in one room, the defense attorney and the insurance adjuster in another room. The mediator goes back and forth in order to try and shuttle back and forth to get the parties to the point where they're ready to settle the case. Now, the one last thing that I want to tell you about mediation is that you should not be surprised if you get into the mediation and it's like, it's like dealing with a rug merchant or buying a used car. In fact, it's usually more detailed and there's usually more back and forth in a mediation than there is when you're buying a car or when you're buying a house. You know, it's a transactional process, and so your demand may be, I don't want to give any particular numbers because I don't know anything about any particular cases here. This is just general information. But let's say your demand is $100,000. The insurance company and the defense attorney might offer $15,000. And then your next move would be to come down from your $100,000 demand. You come down to 90, they go up to 25. You come down to 85, they go up to 30. And there's back and forth until the mediator gets both parties together to settle the case. And I think that people find that process unsettling. Unless you're an attorney handling personal injury cases, it's very unusual. I don't think that there are any other sort of transactional or, any sort of negotiations where you go back and forth in such a manner in order to try and come to a settlement. But in a lot of cases, this is how it's done. And I find that my clients are unprepared for it. You're dealing with someone's life, you're dealing with their personal injury case, and you're dealing with a trauma that they've been through. And I think that the process of the back and forth can cause more emotional trauma to someone who's already been traumatized in a personal injury accident. But this is how it's done, and what you need to remember is that in this back and forth process, your attorney, the plaintiff's attorney, is trying to eke out every cent, every dollar of compensation he or she can get for you, and at the same time, the insurance defense attorney, the attorney defending the case and the insurance adjuster are trying to save every penny that they can and come to a settlement without overspending. And that may seem strange, but that's how insurance companies are. They try not to pay, even when it's a legitimate claim with a legitimate injury. They're looking to get out from under it as cheaply as possible, and that's why you need an attorney there at the mediation to help you and protect you. Well, I'm attorney Ben Schwartz. I think that I've basically exhausted my knowledge of mediation here. If you have any questions, feel free to send me a follow-up email, but I hope that this little lecture on mediation has given you a background on what to expect if you have to go into a mediation in a personal injury case. And I hope that you feel a little more prepared for your mediation if you're searching for resources on the internet about the mediation process. Again, I'm attorney Ben Schwartz. If you have any questions, if you'd like to ask a follow-up question, if you'd like to suggest a topic for another video blog, feel free to send me an email. I'm at ben.schwartz@schwartzandschwartz.com. You can also go on our Facebook page, facebook.com/schwartzandschwartz, and leave a comment there, or send us a message through the Facebook Messenger app. Thanks for watching.